सर आई एम पॉजिंग हियर, 3 पॉइंट दिए इस कोर्ट। कस्टोडियल इंटरोगेशन इन्होंने तो मांगी ही नहीं, उन्होंने कहा आप जेसी जाइए। नंबर 2, आई विल डिसअपियर द एविडेंस। एफआईआर दर्ज किया 1.5 साल पहले, आपने 11 महीने से इन्वेस्टिगेशन इस ईडी की कर ली, उससे पहले फेमा की आप कर रहे हैं। आज तक कोई एलिगेशन नहीं आई है कि मैंने आपके यहाँ से नाकों की तरह एविडेंस लेके आऊं। I have cooperated wherever asked, but you have not even asked the statement. The applicant did not cooperate, gave evasive answers and suppressed facts. Director failed to mention the reason to believe of guilt of applicant under PMLA under section 19. Please mark this from here on. Arrest is discretionary. Discretion is to be exercised wisely, and arrest is not required in all cases. Arrest is to be made when, please mark, custodial investigation regarding proceeds of crime is to be made, or where there are chances that the applicant, if it remains at large, will disappear the evidence or threaten witnesses, or is in a position to hide proceeds of crime to be unearthed during investigation. Third point, that I can hide the proceeds of crime. कि भाई क्या झूठ बोला आपने? But that is the whole point. 417, 420 जो 2 ऑफेंस उन्होंने लिखे हैं, सेक्शन 50 का सब क्लॉज 4 तो पढ़ा, लेकिन विजय मदन लाल और प्रेम प्रकाश की जजमेंट्स में या तो वो कह रहे हैं कि भाई सुप्रीम कोर्ट ने नहीं पढ़ा था। सुप्रीम कोर्ट हैज नाउ स्पोकन अबाउट द एडमिसिबिलिटी एंड इनएडमिसिबिलिटी ऑफ दीज स्टेटमेंट्स आफ्टर लुकिंग एट सेक्शन 50 इंक्लूडिंग सब क्लॉज 4. दैट इज व्हाई दे वर टोल्ड टू गो एंड टेक माय स्टेटमेंट इन जेल.
पर asked for ED custody.
ऑल द मोर रीजन भी दिखा दी ऑर्डर ही मेरे पास होता तो सर मैं नहीं आपको तंग करता. अच्छा, नो प्रॉब्लम. एंड सो after arrest, but it is still that side, because my learned friend is saying कि हम 60 दिन में कभी भी कर सकते हैं under the new law. This is not governed by new law. This is an FIR registered in the earlier law. The investigation of this case has started in the earlier law. CRPC बिल्कुल CRPC अप्लाई हुआ साहब 15 दिन से 15 दिन एंड 15 दिन के बाद वो 15 दिन हो गए खत्म. 15 दिन ही है और खत्म हो गया 15 दिन. नागरिक सुरक्षा संहिता. Such repeal, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made, as the case may be, in accordance with CRPC, as in force immediately. This investigation started prior to 1st July 2024, which is the relevant date. Hence, it must continue in terms of that earlier law under CRPC, last part, as if this Sanhita has not come into force. So this particular arrest, remand and everything else has to be governed by the CRPC, which provided for a 15-day period, and that 15-day period is over, admittedly. Not only that, they never asked for custody even now. According to what they are saying, sir, I have not seen that order. But they are saying, हमने तो 2 दिन सिर्फ जेसी में जाके सवाल जवाब पूछने के लिए एप्लीकेशन लगाई थी. तो अगर वो था, तो जिस दिन ये 50 का मुझे नोटिस देंगे, मैं आ जाऊंगा इनके दफ्तर. वो शेड्यूल में है. But what the court has to consider is, what is the allegation which establishes 420 or 417. आपने कौन सी पावर में जाके चिट्ठी लिख दी, फतवा जारी कर दिया किसी के अगेंस्ट, जाके आप इनके अगेंस्ट इन्वेस्टिगेशन करिए पुलिस में. या आपको नहीं पता था? बेनामी का एक अलग डिपार्टमेंट है, एक अलग स्टैट्यूट है. एक इनिशिएटिंग ऑफिसर साहब वहां पर हैं जिनका काम है ये देखना कि कोई बेनामी है या नहीं है. और आप मेरे साथ सेक्शन 19 और देख लें, फिर 63 पे शुरू होता है और 75 पे रेलेवेंट है. नहीं सर, सॉरी, मेरी बेल एप्लीकेशन. The statement, applicant did not cooperate, gave evasive answers and suppressed facts. Director failed to mention the reason to believe of guilt of applicant under PMLA under section 19. Please mark this from here on. Arrest is discretionary. Discretion is to be exercised wisely, and arrest is not required in all cases. Arrest is to be made when, please mark, custodial investigation regarding proceeds of crime is to be made, or where there are chances that the applicant, if it remains at large, will disappear the evidence or threaten witnesses, or is in a position to hide proceeds of crime to be unearthed during investigation. ये आपके अगेंस्ट ये मटेरियल आया है, आप इसका जवाब दें. मेरे जवाब के बिना मुझे कोई छोटे से छोटा और बड़े से बड़ा अफसर, either on the judicial side or the administrative side, cannot find me guilty, sir. And so, the fact that today it is an admitted position that for 11 months, while I was available for everything else, agency did not come to me, did not record my statement, did not ask me a single question, did not ask for documents, nothing. In that situation, section 19 struck off. 19 has not followed. बैंक स्टेटमेंट में कौन छुपा लेगा किसी चीज को? Discretion is to be exercised by the investigating agency after complying with section 19. No reason has been mentioned in the arrest order. Reason to believe has to be more than a prima facie. Please mark this. Reason to believe is more than a prima facie case. In absence of reference to material on which the reasons to believe is based, the arrest stands vitiated. Provisions of 19 of PMLA are mandatory. Provisions of PMLA places reverse burden on the accused to show he is not guilty, and there is under law that the applicant has committed the offense. Therefore, provision under PMLA has to be strictly followed. Now it is to be seen, if section 19 has not been complied with, then whether the court can grant bail without satisfying itself on the twin conditions of 45. Due to non-compliance of 19, whether rigors of 45 will be wiped out. Arresting officer has to assess the material available in the charge sheet of the predicate offense and also unearth during inquiry and investigation by authorized officer. Such officer must have material on the basis of which he forms an opinion that accused is guilty of the offense under the act. Only then discretion vested in him to arrest is to be exercised. After arrest and bail application, the court will examine the material and reasons given by the authorized officer. If the accused is not guilty of the offense under PMLA, authorized officer has to give reasons of belief of guilt. Court has the reasons of belief of not guilty of the offense to exercise power to grant of bail. So, sir, if I can, before Your Honor reads, if I can dissect it, there are two parts to the reasons to believe. Number one, कि आपके पास ये रीजन होना चाहिए कि मैं गिल्टी हूं, और फिर एक रीजन होना चाहिए मैं अरेस्ट क्यों कर, क्योंकि ऑटोमेटिक नहीं, डिस्क्रिशनरी. दैट इज व्हाट दिस कोर्ट सेड. Sir, 183 is the page number. 182, I'm sorry, 182 is the page number. The relevant paragraph is 41. Sir, 41 का छठी line towards the right hand side, guilt can only be established. Guilt can only be established on admissible evidence to be led before the court, cannot be based on inadmissible evidence. So मेरा statement क्या है और बाकी 9 लोगों का statement क्या है? While there is an element of hypothesis, as oral evidence has not been led and the documents are yet to be proven, the decision to arrest should be rational, fair, and as per law. Power to arrest, please, this one sentence. Power to arrest under 19(1) is not for the purpose of investigation. Arrest can and should wait. The power of 19(1) can only be exercised when the material with the designated officer enables them by recording that I am guilty. This is the first investigative step taken, Kwame. Entire rationale in paragraph 4 is कि सर मेरे को इन्वेस्टिगेशन के लिए इनको जेल में डालना है. सुप्रीम कोर्ट कहती है आप इन्वेस्टिगेशन के लिए नहीं डाल सकते. आपसे, and towards the end conclusion of my submission, sir, I am only placing now 3 questions which I will have to seek judgment on. Number 1, के अफसर साहब जब सेक्शन 19 में किसी को गिल्टी प्रोनाउंस करते हैं अपनी तरफ से, that is not final, it has to undergo a trial and it has to undergo a judicial imprimatur. But ED अफसर साहब जो अपनी जुडिशियल क्वाज़ी जुडिशियल चीज कर रहे हैं, उसके अंदर वो किसी को भी गिल्टी करार देते हैं, it can never be done without following natural justice principles and putting it to notice of that person to say कि आपके अगेंस्ट ये मटेरियल आया है, आप इसका जवाब दें। मेरे जवाब के बिना मुझे कोई छोटे से छोटा और बड़े से बड़ा अफसर either on the judicial side or the administrative side cannot find me guilty, sir. And so the fact that today it is an admitted position that for 11 months, while I was available for everything else, agency did not come to me, did not record my statement, did not ask me a single question, did not ask for documents, nothing. In that situation, section 19 struck off. 19 has not followed.